So in order to give some context to the next three cases that we're going to do, we're going to start off first with a discussion of the Equal Rights Amendment and what happened, and ultimately why did the Equal Rights Amendment fail to be ratified, and serve that as sort of a transitioning point into the discussion of our next three cases. So the Equal Rights Amendment, at least statement-wise, at least verbally, was very simple and simply read that the equality of rights under the law shall not be abridged, denied or abridged by the United States the United States or by any state on account of sex. So simply laws that treated men and women differently solely on the basis of their gender were going to be denied by the Constitution. This was overwhelmingly supported. So in 1971, the House passed it by 350 to 15. And in 1972, the Senate passed it by a similar percentage, with constitutional amendments having to be approved by 2/3 of the House and Senate. Well, it was overwhelmingly approved by both of these bodies. And this is happening, court cases are also percolating through the court system. Reed v. Reed is ultimately decided a month after the House of Representatives passes a draft of the constitutional amendment. So the court is watching this transition take place and seeing that laws which had previously discriminated on the basis of gender were so overwhelmingly unpopular that Congress was willing to act, and that general public opinion at the time was fairly positive for the passage of the Equal Rights Amendment. So they take this sort of as a cue, and you'll definitely see that happen in Reed v. Reed. What is sort of interesting, we need to take a look at the context of the courts at the time. Remember that during really the 50s and 60s, we're dealing with the Warren Court, a court that was overwhelmingly liberal in regards to civil rights of African Americans. However, in gender issues, the court can only be thought of as somewhat conservative. And that conservative nature of the court is even more juxtaposed when you realize the transition that happens under the Burger Court, the Burger Court being seen as a much more conservative court than the Warren Court. But in actuality, in terms of rulings on the basis of gender, the Burger Court is vastly more liberal than the Warren Court was in the area of gender in the law. So it's interesting to realize that the Burger Court is operating and at least taking into account the larger context of the time of what's going on, with at least the initial passage of the Equal Rights Amendment, the general thrust of public support in favor of the Equal Rights Amendment. And the court during the 1970s seems to recognize that and liberalizes its decision-making and rulings in cases that involve gender discrimination. So what ultimately happens to the Equal Rights Amendment is, as all of you know, we did not pass the Equal Rights Amendment. The Equal Rights Amendment didn't become part of the Constitution. Well, very simply, it was simply not ratified by enough of the state legislatures. It has to be ratified by 3/4 of the state legislatures and be enshrined into the Constitution. Well, 3/4 of the state legislatures didn't ratify it, which should seem odd if you think in context of how overwhelmingly it was passed in both the House and the Senate. So what explains, at least in part, why these state legislatures were unwilling to grant this extension, or unwilling to ratify the Equal Rights Amendment? Well, to give some timeline, initially upon the passage of the Civil Rights Amendment in the Senate, they were given 7 years. The states were given 7 years to ratify it. And 38 of the 50 states needed to ratify it by March 1979. They failed to reach that. And so in 1979, Congress passes an extension deadline and gives 3 more years for the states to ratify this. June 30th, 1982 comes and goes, and the Equal Rights Amendment ultimately fails. The Equal Rights Amendment is not enshrined into law, despite what at the time seemed like overwhelming public approval and overwhelming approval of Congress. The Equal Rights Amendment simply does not gain the 38 states needed to ratify it. So why didn't states ratify it? It was by many accounts of the polling at the time, and especially by the accounts of what we look at in terms of passive Congress, very popular. So why didn't 38 states ratify it? If you have time, check that link directly. I will drop it in the description of the YouTube video, and you can see how states acted with regard to the ratification of the Equal Rights Amendment. So you have to understand that while there was strong vocal opposition to the Equal Rights Amendment, it played largely upon traditional stereotypes. And those traditional stereotypes were what was unpopular at the time. And so while this vocal opposition existed and was strongly vocal, that was not enough largely to sway public opinion, because what they were articulating was that women should stay at home. Women are systematically different from men. Women have different roles to play in the household as opposed in the business world. And these traditional stereotypes was exactly the basis that launched the Equal Rights Amendment into the possibility of being passed. So this vocal opposition had to sort of change its tactics, because that what they were selling was not being bought by a large segment of the population. They were largely arguing the same holding that the Supreme Court had in Bradwell, and largely society had moved on in the 100 intervening years since that decision. So they had to come up with a new strategy. And the strategy was new then, but I think those of you who are listening will actually see that the strategy actually plays out very much in a way that all of you have heard within the past 5 to 7 years. What they do is, the reason why, the way that they use their argument is to say, in essence, hey, what about bathrooms? It was interpreted that any law which treats classes differently on the basis of gender would be rendered unconstitutional by the passage of the Equal Rights Amendment. And the worry was, largely starting in the late 1970s and through the early 80s, what that meant was men and women would have to use the same bathrooms in public, that bathrooms segregated on the basis of gender would be done away with. First, there's a constitutional question about whether that would have even happened under the passage of the Equal Rights Amendment. But second, the worries sound very similar to the movements on behalf of states to prohibit transgendered individuals from using their identified, the bathrooms that they identify their gender with. And so this played upon sort of the risk involved of the same genders, of both genders using a bathroom. The traditional tropes we've heard about women feeling unsafe if there were men who identified as women using their bathrooms. And all of these things, as well as they have played in conservative states, played exceedingly well in the late 70s and early 80s with regards to facing off against the Equal Rights Amendment. So really, what those who were opposed to the Equal Rights Amendment hung their hats on was a strategy that we've seen resurface with regards to transgender rights in the 2000s. The logic simply being, as I said, that if all distinctions on the basis of gender were done away with, we would have to use, at least in public, the same bathrooms. And that was a very cogent argument for a large amount of public. And it did sway public opinion pretty aggressively. But at the same time, these gender barriers, at least with regards to the law, were falling on their own. The court, by this time, the late 1970s, had struck down a large number of laws that discriminated on the basis of gender. And the thought was, at least among some progressives at the time, is that perhaps the Equal Rights Amendment was not needed, simply because conservative courts had been striking down these gender-based distinctions. And that's because I think the court realized that this was sort of a moment that was testing their legitimacy. Even the conservative Burger Court was willing to go out and make decisions that struck down these laws based on gender distinctions, and did so in perhaps not a forceful way, as the ACLU, which brought a number of these cases, would have liked, but did it in a way that made unquestionably that distinctions that were based on traditional gender stereotypes simply could not be supported under the 14th Amendment. So while ultimately the court doesn't go as far as the ACLU would like, they do accomplish the striking down of these traditionally based distinctions, even if the Equal Rights Amendment doesn't ultimately get passed.